Okay, there has been some goings on in the First Amendment auditing community about the post office, specifically about uh, Poster 7, about what is policy, what is law, what the post office can or can't do. So, as you see here, I have a copy of the Poster 7, and you'll notice that it says photographs for news, advertising, or commercial purposes. Photographs for news purposes may be taken in entrances, lobbies, foyers, corridors, or auditoriums when used for public meetings, except where prohibited by official signs or security force personnel or other authorized personnel or a federal court order or rule. Other photographs may be taken only with the permission of the local postmaster or installation head. Now, the first thing that you always have to do with something like this, when you're analyzing it, when you're trying to figure out if it is law or if it's not law, is you got to look up the law. And luckily for you, I've done that for you. 39 CFR 232.1, conduct on postal property. This is a law passed by Congress. It's a happy little law. And if we scroll down here to part 5, section I, subsection I don't know how you'd say that. Photographs for news, advertising, or commercial purposes. Boy, this sounds familiar. Except as prohibited by official signs. Boy, sounds familiar. Or the directions of security force personnel or other authorized personnel, or a federal court order or rule. Photographs for news purposes may be taken in entrances, lobbies, foyers, corridors, or auditoriums when used for public meetings. So, when used for public meetings, you can take photographs for news purposes of entrances, lobbies, foyers, corridors, and auditoriums. So if there is a disaster and the city hall burns down and they decide to hold their council meeting in the lobby of the post office because that's the only building left, then you have a constitutional right and a statutory right to go film that. But that doesn't mean that you can always film there just because there's news purposes, because you'll notice it says when used for public meetings. And that's not just auditoriums, it's the whole thing. You can't just say, oh, there's something newsworthy in the lobby. I have determined it's newsworthy. I'm going to go in and photograph it. It's when it's used for public meetings. It continues, other photographs may be taken only with the permission of the local postmaster or installation head. So the postmaster can say you can or can't do it, unless it's being used for a public meeting. So you go back to your photographs for news purposes may be taken in entrances, lobbies, foyers, corridors, or auditoriums when used for public meetings, except where prohibited by official signs or security force personnel or other authorized personnel or a federal court order or rule. Other photographs may only be taken with the permission of the local postmaster or installation head. So it looks like this poster is not policy, it is law. You'll also notice there are penalties and other law listed over here. It's not really important, but yeah, they can impose federal fines. This is you got to understand that is a federal law. I read Code of Federal Regulations. And so it is a federal district court or federal magistrate that will be hearing it. And you, if you're sentenced for actual prison time, you would be serving that in a federal prison. Now, they also have the power to control what goes on their property. And people always like to say, well, it's public property. So obviously I can go there and, you know, it's public, so I can film in public. We're good. This is the U.S. Postal Service versus Council of Greenberg Civic Associations. This is a 1981 U.S. Supreme Court case. It's 453 U.S. 114, if you want to look it up yourself. I am in the main decision. So I'm not in a dissenting opinion or anything like that. This is 453 U.S. 129. And this is an important part. Indeed, it is difficult to conceive of any reason why this court should treat a letterbox differently for First Amendment access purposes than it has in the past treated the military base in Greer v. Spock, which I strongly recommend you look up, the jail or prison in Adderley v. Florida, which again I strongly recommend you look up, and Jones v. North Carolina Prisoners Union, or the advertising space made available in city rapid transit cars in Lehman v. City of Shaker Heights. In all of these cases, this is where we're getting good. In all of these cases, the court recognized that the First Amendment does not guarantee access to property simply because it is owned or controlled by the government. I'm going to repeat that because it's important. In all of these cases, this court recognized that the First Amendment does not guarantee access to property simply because it is owned or controlled by the government. Yes, yes, yes. We've got an update available. In Greer v. Spock, Supra, that means above, the court cited approvingly from its earlier opinion in Adderley v. Florida, again, cited above, where it explained that, now we're quoting from Adderley v. Florida, the state, no less than the private owner of property, has the power to preserve the property under its control for the use to which it is lawfully dedicated. And that's important because the use to which a post office is lawfully dedicated is to sell stamps, send mail, offer a place for post office boxes, things like that. It is not intended to be a traditional public forum. And now you're going to say, oh, traditional public forum, that sounds interesting. I'm going to continue on. This court has not hesitated in the past to hold invalid laws to which it has concluded granted too much discretion to public officials as to who might or might not solicit individual homeowners, or which too broadly limited the access of persons to traditional First Amendment forums. Oh, what is this? To traditional First Amendment forums such as the public streets and parks. It has just done an analysis of the First Amendment for this case for traditional public forums. Now, I'm going to rely on, this is umkc.edu. This is a law school, apparently. I don't know. I picked it because they had different sections for the 3 basic designations. And I'll provide links to these in the descriptions if you want to go through them. But you see here, restricting speech in the traditional public forum, defining the forum. So what is a traditional public forum? A traditional public forum are public sidewalks, parks, street corners, plazas, places where people have gone traditionally to stand on their proverbial soapbox and tell you about the good news of the Lord, or to say, the end times are upon us, or communism is bad, or capitalism will kill you, or whatever they want to say, however they want to say it. This is where people go to hand out leaflets, to get people to sign petitions. Public forums, any place where you normally see that kind of thing that is a public place, is a traditional public forum. Now, how does the court determine what a traditional public forum is? I just basically went through it. Public plazas, public parks, public sidewalks, and the government can control a little bit. It has to be viewpoint neutral. They can only have time, place, and manner restrictions. So they can be like, oh, you have to get out of the park from sundown to sunup. Oh, that's a time, place, or manner restriction. they can do that. They're not saying you can't talk about, abortion or whatever. They're just saying that, time, place, and manner restrictions. So, you're on the street corner, you can't use an audio amplified device that goes above this volume, because it, and they have to have like a legitimate kind of reason for it. It's a strict scrutiny kind of analysis. So that's a traditional public forum. Then there are non-public forums, and non-public forums are places where you don't have a right to speak. The government can really control what gets said. They can control even like the viewpoint of it. So like they can say on a military base, you can't have any sort of seditious, or not necessarily seditious, but you can't have any like anti-government speech. They can control that a little bit better. Oh, nice. Lou sent me an attachment. That's awesome. So the government can control what you say pretty much 100% on, yes, thank you. They can control pretty much what you say 100%. They control when you say it, how you say it. They can deny you the access to these places to speak. So the traditional kinds of places you look at that are non-public forums are going to be military bases, prisons, and jails. Those are basically the government has complete control over what gets said in those. And then there's this kind of middle ground, the limited or designated public forum. And what that is where the government has opened up a space, a place that traditionally isn't a public forum. Like, say, for example, the foyer of a post office. That's not a traditional public forum. People haven't gone there traditionally to air their grievances, to hand out flyers or get signatures. That is not a traditional public forum, but the post office may open it up for public speech. And if they do so, it becomes a limited public forum. They can't really control what you say or how you say it for the most part. They're going to be limited to time, place, and manner restrictions. But they have to open it up for it. Schools are a big example of this. If the school opens up after school clubs, then they can't say, oh, we can't have if you have a Christian club, you can't have it. If you have a communist club, you can't have it. They have to, if they're opening it up to after school clubs, it has to be viewpoint neutral and fun stuff like that. So very, very limited once they open it up, but until they open it up, then they can stop people from speaking at all. So that's why a lot of this analysis is so wonky on the post office. People are saying it's public access, it's owned by the public. It doesn't matter. It really doesn't matter. What matters is it a traditional public forum? Is it a non-public forum? Is it a limited public forum? If it's a limited public forum, which it would be if they opened it up, the foyer or whatever, then all of a sudden you have more First Amendment freedoms there. Until they do that, then you have a very limited set of freedoms. They can control photography. We have law. It references the poster. We've got the poster. They can trespass you from the post office. There is a federal trespass statute. There are local trespass statutes. It says they may work with local law enforcement. If local law enforcement hems you up, then it would probably be a state trespassing law. If it's the postal inspector that hems you up, it'll probably be the federal trespass statute. If they decide to trespass you, if they don't, then what have you. But yeah, so Anybody telling you that you have a right to film in a post office? Not yet. The courts haven't said that you have that right. So I don't know what they're saying. Currently, we have statute that says you don't have that right. There is no Supreme Court or even appellate court decision that I'm aware of for any of the district courts that would give you that right. So if somebody knows one, please put it in the comments below. I'd be happy to take a look at it. But until a court says you have that right, all we have are statutes that say you do not have that right. So anybody telling you otherwise, always check with the local attorney, because you don't know what the local laws are. But it does not appear that there is anything that says that you have a right to film at a post office, period. Thank you for watching and have a wonderful day.